Well, welcome to a special little interview we've got here with the man of the hour, the hero of the hour, Marc Randazza. He is, full disclosure, my attorney in one of the cases against the Massachusetts State Police. And of course, the protesters case, which is going to be the subject of our quick little interview here. And of course, Mr. Delgado's case, which involved the ripping off of his sticker. And now a brand new case with Erica Walsh. So you got nothing else to do. I'm glad I could catch you. You're moving from one place to another constantly. So thank you, Marc, and congratulations. Give me your sum up for me what we've got here.
Okay, so what we have here is a supplemental order from Judge Canon, which, she essentially declares, I'm still declaring a buffer zone, but that buffer zone is going to comport with the First Amendment. And there's a lot of rigmarole in it, but what you get down to at the bottom is really what the operative part of this is. And she says, quiet, off-site demonstrations on public property in areas and at times that do not interfere with trial participants' entrance into or exit from the courthouse, and that do not interfere with the orderly administration of justice, and that are not intended to influence any trial participants in the discharge of their duties, are specifically outside the scope of the buffer zone restrictions. Okay. That's it right there. So what that means is the zone is really what the law was in the first place. So it's she has finally capitulated to the fact that the First Amendment applies even in Norfolk County. So
crazy.
If people want to go out there and protest, we certainly could have argued that we have a right to be loud. The First Amendment doesn't require you to be quiet. We didn't want that. Sometimes, my dad taught me when I was a kid. My dad was wound up negotiating for his union at one point. He came home and I was just a kid. And I remember him saying to me that he got everything he wanted because he asked for what he wanted. You don't necessarily ask for $1 billion if you really want $1 million, depending on how, depending on the forum. Sure, sometimes there's people you got to haggle with, but this isn't a bazaar in Marrakesh. This is the law. Now we have reasonable protesters out there. If you want to go out there and protest, please do it. We worked really hard to get you that right, but be a good example. Even if you might have the right to go out there and scream and swear and do whatever, why do it? You're way more effective. You're way more effective because I will guarantee you these assholes are looking for any opportunity to screw you. So go out there and make your speech speak, not the way you act. Don't look at Antifa and say that's how we act. We should act better than that.
We don't want mainly peaceful protests with buildings burning in the background. Is that what you're saying?
No, exactly. We'll do something that the Boston Globe will call violent because somebody slaps a mosquito off their arm. But there's a reason I'm giving you an interview and not the Globe. But if you go out there and you're holding up signs that say whatever you want, of course you can't unnecessarily intend to influence a juror. The law already prohibits that. So this is what's called a mens rea. You need an intent to do something. You can't just be guilty by reason of being there. So it's all in all, it's a good order. It just shouldn't have taken this to get there. And I'm quite disappointed in the fact that this judge couldn't come up with this on her own. I'm disappointed that last year when we tried to talk sense into her, she really, if you were in that courtroom that day, she was angry about the fact that we were trying to intervene. The Massachusetts Supreme Judicial Court was so desperate to not do anything about it that they wrote an opinion, Spicuzza, that completely excludes the issue of public sidewalks, where they falsely said we didn't raise that, where it's all over our pleadings. But hey, I understand. You got to do what you got to do to protect the judges' union. Well, now the Spicuzza decision is garbage, useful for nothing. So it's not technically overruled because that's not how federal and state courts work. But if you're citing Spicuzza for anything, you're going to lose.
Yeah.
Then we went to the federal court, who just was wrong on the First Amendment, just dead wrong, didn't seem to get it. And then we get to the First Circuit where they finally got it. It took some doing, but they got it. And they told her she better clean up her act. And, really they told the lower court, clean up your act. The lower court wouldn't do it. We'll sit around for another week. Maybe she'll do something. Maybe they won't. Jeez, come on, guys. So then we file an emergency motion to the First Circuit, which says you got 48 hours to straighten out your act. Well done, First Circuit. Now, credit where it's due. Well done, Judge Canon. You finally got it right.
Yeah, and that's not all that normal for a reviewing court to put a time limit on something like this, but they understood it and they enforced it.
Yeah, I mean, I think they trusted that either Judge June would do something or Judge Canon would do something during her time that she could have. And I think they finally realized that the court's delaying was almost telling the government, go ahead and do whatever you want. We're not really going to ever do anything. And that final motion to enforce their order finally got it done.
Okay, so follow up on two different areas. First of all, let's talk practical application here. We know what happened last time. There was an area near the church, which technically is still in the buffer zone, right? Technically. So in that expanded buffer zone, can people go now? They can hang out. They can throw their lawn chairs out there. They can peacefully assemble.
Go right back to it. Yep. They have full First Amendment rights. They are only constrained really, by laws that already exist. So Massachusetts already has a buffer zone in the entire state, 268 Section 13B, which essentially stops you from intimidating people or interfering with people in the in the process of justice. I'm not going to quote the whole thing because I can't, but look, you cannot go and try to intimidate a witness. You can't try to untowardly influence a trial. What happens in the trial happens inside that courtroom. That's what the Sixth Amendment requires. So
in theory,
yep.
If we go back to the pretrial period where supporters were gathered at the foot of the stairs,
yes,
they at times would say, supportive things to Karen Reed and maybe some snide comments to the prosecution. Absent those activities, just presence, can they be there?
Sure they can. But what they cannot do is they cannot impede people coming in and out. So, just act like we live in a society. I mean, I realize that's a little difficult in the United States from time to time. It's like sometimes I scream that as I'm getting on an airplane. I'm like, come on, we live in a society. Act like it. So when you're down there, if you're protesting, act like we live in a society. Act like those jurors are your friends. And, even yelling at the prosecutors, why? What are you getting out of it? Take the high road, please. You don't have to. You have a right to be as big a douchebag as you want. But man, take the high road so that when people are photographing you and filming you, if you want your cause to have more power, do that. I mean, do what you like. But I'm just giving you some optics advice. Okay. You want to be. There's a reason where when you saw like the marchers at Selma, they were wearing suits and ties. And there's fire hoses turned on a bunch of people acting with dignity. So go out there and act with dignity and don't give the state police an excuse. And when they do something, which I'm going to, if you're betting that the state police aren't going to step over the line, that's a sucker's bet. So when they do it, let's have that video of them doing it be beautiful evidence that when somebody watches that, they say, how could they do that?
And we've seen enough of that already, but that was my next question, which was, okay, this is lovely in theory, but in practice, I find it hard to think that there's not going to be altercations, and I don't mean physical, I mean verbal and resistance and arrests.
Yeah, well, here's the really nice thing about Judge Canon's order. So as much as I might be disappointed in her in the past, I got a funny feeling. So the lawyer who represented the Commonwealth, Mr. Hitt, was I really have to give him credit. He handled this case with class, with dignity, with ethics. I really enjoyed working with him. And he had a job to do. I didn't agree with what he did, but I really can't shit on him one bit. I sense that he had this other piece put in that order that you get a prompt hearing if anything happens. Now, I still question whether Judge Canon even has any power outside the courthouse, but we want to solve the problem for today. We'll go back and get that machine gun nest dug out later. But for now, a really nice thing in there that we didn't even ask for. So I've got to give him, I'm giving him the credit because it smells like his work. Just his reverence for the Constitution is clear. Although might have been Judge Canon who came up with it on her own, might have been somebody else. I don't know who to give credit to for this to, but don't give credit for this part to me because I didn't even come up with that.
So I know there was some attempted cooperation when you were at the circuit court level where they were trying to say, well, how do we craft something everybody can live with, right? Was this ever discussed in that forum?
No, that is brand new stuff. And, I think now you can look at it one of two ways. It's either clever because what they're trying to do is make sure you can't get back to the federal court because they don't want the First Circuit looking at them again.
Seem to have lost Mark. Mark has been lost. Did the troopers get a hold of him? We're going to get him back. I know he's going to pop back up here. We just lost the signal. Mark, if you can hear me, sign in again. So this is the part they added that, as Mark suggested, they didn't even ask for. Fifth, any person whose activity has been restricted by an officer enforcing this order, which basically means that their interpretation of the order, right, may request a review. Oh, hold on, let me get Mark back in here.
Hey,
there you go.
Sorry about that. I don't know.
I thought the troopers got you. I was just reading this fifth provision so folks can understand that you may request this review by a judge of the Superior Court, which request shall be heard as expeditiously as possible. Put your own spin on that.
Yeah. So that's not bad. What that allows is that we don't have to go to federal court. So maybe theoretically you can run right into the courthouse right there. I mean, if the spirit of this is that you're going to have what you did expeditiously reviewed, great.
Yeah, and I think that mechanism will be used. Okay, I'm going to do something. I'm an attorney, so when I say I only need 10 minutes, which is what I told you, I just need 10 minutes. It's already 12.
Briefly, Your Honor.
just briefly.
When somebody says briefly, Your Honor, there should be like an increasing amount of pain that you have to like wear a collar that constricts on you.
There you go. The shock vest. Maybe the shock vest will work. Here's my thought. This is all revolving around case number one, the protesters case. I've been calling it. We have number two, the journalist case, myself and Tom CPU, and then we have the Delgado case, and then we have the new Erica Sloan case. How does this impact? Let's start with the journalist case.
All of them, because this clearly covers journalist activity. I don't want to give you advice as attorney-client here on the air, but I will say there is not a thing you and Mr. DeRozier can go back to filming, interviewing, news gathering, because absolutely, if you look at that last paragraph of this new order, absolutely, that stuff is outside of what the buffer zone is supposed to be stopping. What Mr. Delgado was doing, absolutely. I mean, in fact, it seems, now I don't want to stipulate to anything on the air here, but we are considering whether the injunctions we've sought in your case and in Mr. Delgado's case are moot at this point. Because if the order does clear the deck for you to do what you want to do, for him to do what he wants to do, and even now for Ms. Walsh to walk through there wearing her Norfolk County Criminals sweatshirt, or journalism is not a crime with Turtle Boy's picture on it, doesn't seem like this limits that at all. So this may have happened because of the Grant case, but I believe it cleans up all of the at least immediate issues. We still have other issues to clean up in this case. I mean, the case is not over, but the really important part is I wanted to be able to see people standing there holding signs that say, "Hey, free Karen Reed," or jail Karen Reed. I am agnostic, or just holding up, signs saying, come to my church, whatever you want. But that is what's important. And I am just thrilled that we've managed to get this done, because it was a long, hard fight. I mean, it really, the fight started last year in the last trial. And, and everybody said, well, you won't be able to change it. The SJC already spoke, and everybody wanted to lazily just say that lazy garbage Spicuzza case was the one that controlled. Well, I had kind of hoped that Spicuzza's name would be synonymous with liberty. I actually purposely chose the Italian name because it's the courthouse where Sacco and Vanzetti got railroaded.
There you go.
But I'm sorry, Mr. Spicuzza.
Yeah, maybe not something you want to be known for. Yeah.
Well, that's why every time I say something bad about the Spicuzza decision, I say the Spicuzza decision, not going to dishonor Mr. Spicuzza.
Well, sir, great work. We appreciate it. I will be up there again next week, testing the waters as I'm sure they will. Yes,
and
sir.
Let's give a shout out to the organization that really made this happen, the Center for American Liberty.
Yeah.
So they're a great group of patriots that support cases like this. So if anybody's watching and they're happy about this, look up Center for American Liberty online and toss a little donation in there. Hell, even if it's $10, just let them know that they're there and that you care about what they did, because they're filling in the holes that there's that other organization that used to care about the First Amendment that doesn't really care anymore. Well, you got Center for American Liberty, and remember at the First Circuit, we had amicus briefs also from organizations. The National Press Photographers Association was particularly interested in your problems in this case. There was also the First Amendment Lawyers Association, a group of First Amendment lawyers that I used to be president of. I didn't get voted out; I just termed out. They checked me out.
Thanks for clearing that up.
and the Foundation for Individual Rights and Education. That's their website's thefire.org. So those are just, there are groups that care about all this, and I think it's good for everybody to be aware of them. But mostly, give a huge round of applause to the Center for American Liberty.
Yep, they were great, and give Daytona a hard time. She was the one who liaised with me, and she was great. She was great. So, yeah.
And Marc Trammell was my counsel from there. We got him signed up with a First Circuit license for this, and I'm looking forward to working with him a lot more. He's a great guy. Okay.
I know that you probably can't talk about it, but I read about some other case you just launched just recently. What you got anything new that's on the back burner there that is now in the front burner?
I can't even keep track of everything I'm working on, but we did just get a big win in Maine for the First Amendment for Sean McBriarty. And he was a guy, and this is another case that the Center for American Liberty backed. Mr. McBriarty published an article on his website about some students who circulated a petition at their high school in Brewer, Maine. And the principal and the superintendent threatened them with a hate crime because they were circulating a petition that they didn't want transgender students in the women's bathroom. And set aside how you feel about that issue. You can be pro boys in the girls' bathroom. I don't really care. But to try to stifle these high school kids was just unbelievable. Well, it was even worse. Mr. McBriarty wrote about it and published a picture along with it. And the school district threatened him with criminal sanctions and civil sanctions if he didn't take down material that they didn't like in that article. And they're just so power drunk up there in Maine that they actually thought they'd get away with it. And unfortunately, Mr. McBriarty passed away halfway through the case. And he was a dear friend of mine. I had known him before, but we became friends throughout the course of the case. In fact, we'd talk every Sunday and agree that we wouldn't talk about the case. We'd just talk about life and stuff. And I was really broken up when he died, especially since the case wasn't going well. And now we won at summary judgment. So posthumously, when your friend passes away, you always think about what can I do for him? Hey, here's my best friend, died in 2016. His ashes are in his flask.
Wow.
It's the best I can do for him.
Wow.
But if you can build a monument to your friend or get a really good First Amendment win named after him, it's a pretty good day.
Not bad. Well, you continue to fight the good fight there, Mark. We appreciate your work, the result in this case. I hope it doesn't become, an issue with the interpretation of what the courts have decided, but we will see.
I mean, it's painfully clear. As much as she tries to kind of dance around the whole thing, by the time she gets to the end, by the time she gets to the finish line there, it's a pretty darn clear order that as long as you're not breaking, 268.13b, as long as you're not intimidating people, blocking people, or, disturbing the peace, you're good.
Well, we do know that one of the key defendants in virtually every case has maybe his own interpretation of that statute. And that's what we're going to see play out, I think.
Mass State Police, watching you.
Thanks, buddy. Appreciate it. Best of luck. And I know you got to get on a plane. Take care, man.
All right. Take care. Bye.